Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to have a look at the case of Canada and Crawford, and this is another of these Section 74 jurisdiction questions. This one could also be described as Fradsham Strikes Back. I thought about doing a thing here with the theme music, but for just thinking about it, Disney sent me a cease and desist. That was a joke, mouse. Stay away. Anyway, so this one is a case that has the rather unique situation where Judge Fradsham wrote the Stark decision, and some other courts considered it and didn't receive the Stark decision very well. They rejected the reasoning in Stark. And now Judge Fradsham has another of these Section 74 jurisdiction questions, and so is going to have the opportunity to review those other cases that rejected his reasoning and either say, yes, I was wrong, and I accept the reasoning of the other courts, or no, here's why I'm still right. Let's have a look and see what's going on here. So as noted, Provincial Court of Alberta, Attorney General in Crawford, and Judge Fradsham. So introduction. The application before me is another in a series of identical applications made by the Attorney General for Canada in relation to applications under Section 74 of the Firearms Act, filed in various provincial courts by individuals who hold firearms registration certificates in relation to firearms which were previously classified as restricted and were reclassified as prohibited firearms by the terms of a regulation made by the Governor and Council on May 1st, 2020. If you are not familiar with the Firearms Act, Section 74 is a broad provision that allows for challenging certain decisions made by the Chief Firearms Officer or the registrar when those decisions either refuse you a license or registration certificate or certain other things, or revoke one that you already have. So that's what that section is for. It's a very important section of the Firearms Act. Briefly stated, subsequent to making the regulations, the Registrar of Firearms sent to Mr. Crawford and to others in his position a letter, the Registrar's letter, which Mr. Crawford and some others who received it took to be a notice under Section 72(1) of the Firearms Act that the Registrar had revoked certain registration certificates particularized in the letters. Now, when I say took to be a notice under Section 72(1) actually has a number of legal requirements that are things that it must do. This letter does not do those things. It doesn't fit the requirements of that notice. But that doesn't necessarily mean it's not a letter, because otherwise it would be this weird situation you'd have where the registrar could say, listen, we didn't do our jobs, and because we didn't do our jobs, you're not allowed to tell us we did wrong. That seems to me to be a backward application of the law, and the courts have rejected that argument in some other decisions in the past. In particular, Runkle v. Alberta / Runkle v. Canada, that argument was rejected. All right, continuing on. In the case of Mr. Crawford, he filed in the Provincial Court of Alberta a Section 74(1) Firearms Act application for review of that revocation, the review application. Some other recipients of the letter filed similar applications in the provincial court of the provinces in which they reside. As far as I know, I think there's been at least one filed in every province. The Attorney General takes the position that the Registrar's letter did not constitute a notice of revocation, and therefore the Provincial Court of Alberta, nor any of the other provincial courts in which similar Section 74(1) Firearms Act applications were filed, has jurisdiction to hear the filed review applications. As far as I know, the Attorney General has consistently taken that position in respect of all Section 74 Firearm Act applications filed in response to the Registrar's letter. And that's as far as I know, too. I haven't heard of any case where the Registrar said, yes, we're going to concede jurisdiction and proceed directly to a hearing on the merits. So that has led to the Attorney General filing, in response to each of these filed Section 74 Firearms Act review applications, including Mr. Crawford's review application, a preliminary application seeking an order striking out the review applications on the basis that the court does not have jurisdiction to hear the review application. So what they're trying to do is they're trying to knock it out before the hearing. There's whole issues as to whether or not they can, but they've been successful in doing so in a number of provinces and a number of courts. Apart from the ruling I made in Canada and Stark, and its companion cases, the Attorney General has been successful in its applications to strike. And there's a big footnote there. I'm going to jump ahead to the footnote because it's important here. And that footnote is the Attorney General's application in Philippines and Canada was dismissed on the basis of a deficient record. Philippines and Canada has a number of companion cases. One of those is my case. I was there arguing that one. That's one that I have previously done a video on, which hopefully will be coming up here. And so that one was dismissed because they said that the letter itself is not sufficient. But the jurisdiction question is still a live issue in that case. It's just that the application to strike has been dismissed and it's moving on to a full hearing, including on the jurisdiction, or rather first on the jurisdiction issue. So the issue has come back before me by way of the Attorney General's application to strike Mr. Crawford's Section 74(1) review application. Having now had the benefit of the reasons for the rulings made by my judicial colleagues in various provincial courts, I will revisit the issue. So as I said before, the judge here is saying, listen, a bunch of other judges in other jurisdictions have ruled in different ways and typically against Stark. So this Judge Fradsham is going to say, listen, I'm going to look at those other cases. Maybe I'm wrong, or maybe let me explain why I'm still right. A reference in these reasons to a section number is, unless specifically stated otherwise, a reference to that section in the Firearms Act as amended. Issues. The overarching issue in this application is whether the Provincial Court of Alberta has jurisdiction to hear the application filed by Mr. Crawford in which he purports to invoke Section 74 of the Firearms Act. I don't know if I covered this in a previous video, but jurisdiction is the question of whether the court has authority over a particular issue. Often jurisdiction is tied to location, because one of the common ways that the court might not have jurisdiction is, let's say I went to the Provincial Court of Alberta and asked them to deal with an issue that is happening entirely in the United Kingdom. And I said, that thing that's happening in the UK, I don't like it, please stop it. And the court would say, we don't have authority over the UK. We don't have jurisdiction. But there are issues where the court may not have jurisdiction, even though it's happening here in Alberta. So that's essentially the issue here is, does the court have authority over this particular topic? The primary issue is whether the letter sent to Mr. Crawford by the Registrar of Firearms constituted a notice of revocation of certain registration certificates under Section 71(1)(a) of the Firearms Act. So if it is a notice of revocation, then the court does have jurisdiction. If it's not, if it's something else, then the court may not have jurisdiction. So facts. They're going to go through the registration certificates he's got. I'm going to skip over that for time because trying to keep this video digestible. Each of the firearm registration certificates he was sent had printed above it a message which contained, amongst other things, the following statements. The firearms registration certificate is issued to the owner for a specific firearm. The registration certificate is valid until the firearm is transferred or disposed of, or the certificate is revoked. This firearm registration certificate is issued by the registrar under the authority of the Firearms Act. You can already see some interesting stuff here. Until the firearm is transferred or disposed of, or the certificate is revoked. That's a small list. Now, that's actually not a complete and exhaustive list. There are some other ways in the Criminal Code and the Firearms Act where a certificate can be terminated. But it doesn't seem that there's any way that isn't enumerated in law. On May 1st, the Governor and Council made a regulation effective that day, under the terms of which certain firearms previously classified as restricted firearms were reclassified as prohibited firearms, and also certain firearms that were previously classed as non-restricted firearms were reclassified as prohibited firearms. So let's, I'm going to skip over this whole list. If you want to see the list of things, I've got that in some other videos, and also you can just check the regulations yourself. But for time, we'll skip over that today. They also note that the Governor and Council made an amnesty order, which provided for people to continue to possess those things up until May of 2022, April 30th, 2022. So I'm going to skip over what the amnesty order allows you to do as well, because, again, other videos. The Registrar of Firearms sent to Mr. Crawford, who resides in Airdrie, Alberta, a letter dated July 20th, 2020. The letter said, and I'm going to skip over the letter because I've covered the letter in other videos, but this is the letter that they describe that purports to indicate that the registration certificates are automatically nullified and are therefore no longer valid. So the only key bit to this letter is these firearms listed below are now classified as prohibited, and the previous registration certificates are automatically nullified and are therefore no longer valid, but should be retained as a historical registration record. The letter then listed the 2 registration certificate numbers and the corresponding makes, types of firearms, serial numbers, and firearms identification numbers, all as noted above. In listing the registration certificate numbers, the letter described them as registration certificate number no longer valid. Mr. Crawford filed with the clerk of the Provincial Court of Alberta a reference to a provincial court judge, Form F12 of the Firearms Act, dated August 18th, 2020. The reference sets out that Mr. Crawford is applying for review of the following decision: revocation of a registration certificate. And as a preliminary matter, the Attorney General for Canada brought the application, which is presently before me, for an order striking out the reference to a provincial court judge. The basis for the Attorney General's application to strike is, generally described, that the Registrar of Firearms did not revoke Mr. Crawford's registration certificates, and consequently, the prerequisites for invoking Section 74 of the Firearms Act do not exist, with the consequence that no judge of the Provincial Court of Alberta has jurisdiction to hear Mr. Crawford's reference. All right, so that is some dense language here. Let's try to break this down a little bit. When they're saying that the prerequisites for invoking Section 74 of the Firearms Act do not exist, and again, that's the Attorney General's position, what they're saying is that Section 74 is only useful for a revocation or a refusal done by the Chief Firearms Officer or the Registrar. So they're saying that's not what happened. What happened is just that these letters were canceled by something else that happened outside in the universe, and that we just sent you sort of a courtesy note to say, hey, just so you're aware this happened. One kind of wonders why that would be necessary, because people are presumed to know the law. And so why would they send out these letters, which is not cheap, by the way. It costs a fair bit to arrange a mail out like this. Why would they send out these letters just to let you know of something that you're already presumed to know? So that kind of raises an interesting question, at least in my mind. So law and analysis. In Canada and Stark, I set out my reasons for concluding that the Registrar of Firearms, by sending the July 2020 letter, which was identical in content apart from the particulars of the firearms affected to the letter sent to Mr. Crawford, was telling the letter's recipient that the registration certificates mentioned therein had been revoked. Except to the extent necessary, I will not repeat, though I do rely upon those reasons, and there's a little footnote here that notes, in that decision, I explained why I equate the terms nullified and no longer valid with revoked. I covered that case previously, so you may want to go and check out that video as well. I'll try to remember to link it here. If you don't see a link here, let me know in the comments and I'll try to remember to fix that. As noted above, the conclusion arrived at in Stark has not been the conclusion reached by my judicial colleagues in other provincial courts. The conclusions reached in other cases decided on the merits is well represented in paragraph 30 on the decision in Hewlett in Canada, which is another provincial court decision. And it states, the essence of my decision to reject the applications of Mr. Hewlett and Mr. McShane is set out in paragraphs 58 and 59 of the Carina judgment, which for ease of reference are quoted herein as follows. So what we've actually got is a double quote. This is a quote of the Carina judgment, which is being quoted in the Hewlett judgment, which is being quoted in this current case that we're reading. The direct consequences of the regulations was to extinguish the legal validity of certificates of registration issued previously for prescribed restricted firearms that are now prescribed as prohibited firearms. Effective May 1st, 2020, there was in law no registration certificates available for such firearms described as restricted firearms. Such firearms were no longer restricted, so no restricted firearm registration certificates have any validity or could come into being. The nullification, revocation, or invalidation of the applicant's registration certificates came into effect on May 1st, 2020 by operation of law. That effect was not dependent upon the Registrar of Firearms deciding at some point, therefore, to revoke, or thereafter, rather, to revoke. There was nothing to revoke. The registration certificates had no legal validity effective May 1st, 2020. This is made even more clear by the fact that the regulation or the amnesty regulation that was issued in conjunction complements and the two orders in council when read together. demonstrates that the subject registration certificates of the firearm owner no longer have any legal validity. The amnesty provision comes into effect the moment the nullification of the registration certificate occurs by operation of law, that is, May 1st, 2020. The amnesty regulation does not perpetuate the certificate of registration, rather it forgives the unlawfulness of the possession because no registration certificate exists for the subject firearms any longer and protects against prosecution for a specific period, provided certain circumstances exist. The legislative body, in this case the governor and council, is presumed to know that immediately upon the regulation coming into effect that the registration certificates for all those previous restricted firearms now prescribed prohibited are no longer legally valid, and that the holders of those firearms are in unlawful possession thereof, hence the amnesty provisions. There is no need for amnesty if the certificates of registration still have lawful validity after the regulations come into effect. Now I'm going to stop this quote here and say that decision in that previous case is dead wrong in terms of its application of the law, because if you have a registration certificate, you can still be charged for having one of these firearms. So having the registration certificate isn't a guarantee against prosecution. If you have a license that only allows you to have non-restricted firearms, and yet you have a restricted firearm, and for some reason somebody has screwed up and issued you a registration certificate, you're still actually in violation of the law. So when they say there is no need for amnesty if the certificates of registration still have lawful validity, that's not a correct application of the law. That is just, in my view, plainly wrong. So the registration certificates that the applicants assert were revoked by the registrar of firearms through the letter of July 20th, 2020 ceased to exist on May 1st, 2020 with the coming into force of the regulation as described aforesaid. There was, after that point, nothing to revoke. Indeed, if the registrar purported to be revoking the subject certificates of registration pursuant to Section 71A, that mistake would not change the fact that there was nothing of legal validity to revoke. There was nothing to take away as the registration certificates for the former restricted firearms ceased to have any legal validity or existence other than as pieces of paper. Again, that is in dispute, but that was the finding in that case. Right now, there's a whole bunch of decisions from a whole bunch of different courts which are going in different directions. So, in short, according to Hewlett and Canada Attorney General, the effect of the regulations was to extinguish the legal validity of registration certificates issued previously for prescribed restricted firearms that are now prescribed as prohibited firearms. So they're saying this is the thing in the universe that I was talking about, that the regulations killed those certificates. The nullification, revocation, or invalidation of the registration certificates came into effect on May 1st, 2020 by operation of law. That effect was not dependent upon the registrar of firearms deciding at some point thereafter to revoke. There was nothing to revoke. The registration certificates had no legal validity effective May 1st, 2020. So basically they're saying they're kind of reading in something into that regulation that isn't there, which is a revocation. They say to test that analysis, it is necessary to review the relevant statutory provisions. So Judge Fradsham is going to say, do I agree with that analysis that was provided in Hewlett, and quoting another case, Curina. So they say, it is a criminal offense to possess a prohibited firearm if one knows that one is not the holder of both the license to possess that firearm and a registration certificate for that firearm. Section 92(1) of the Criminal Code. The Firearms Act states that a person is not eligible to hold a registration certificate for a firearm unless the person holds a license authorizing the person to possess that kind of firearm. Section 13. And the hold language is very, very important here, because holding a registration certificate is different from possessing a registration certificate. Eligible means meeting specified preconditions. And a registration certificate may only be issued for a prohibited or a restricted firearm, Section 12(1) of the Firearms Act. The registration certificate is valid until it is revoked, and that's bolded, or it expires, which is also bolded. Indeed, that was the message given by the Registrar of Firearms to Mr. Crawford when the registration certificate was given to him. The firearms registration certificate is issued to the owner of a specific firearm. The registration certificate is valid until the firearm is transferred or disposed of, or the certificate is revoked. The reference to transfer or disposed of would cause the registration certificate to expire. and the reference to the certificate is revoked is self-explanatory. So essentially, the Judge Fradsham here is pointing out that the law only allows for the cancellation or termination of a registration certificate in a limited number of ways, and is about to go through an exhaustive list of the ways in which a registration certificate can be revoked. So a registration certificate can be revoked in 4 ways. The first 3 are pursuant to Section 71 of the Firearms Act. The 4th way is by operation of Section 116 of the Criminal Code. This is an important section of the Criminal Code if you deal with firearm stuff, but not a huge issue here other than the fact that it exists. So a registration certificate may be revoked by the Registrar of Firearms for any good and sufficient reason, which means that the law doesn't actually specify what those good and sufficient reasons are. That's something that's left to future courts and to the registrar themselves to decide. But the Registrar of Firearms can decide what a good and sufficient reason is, and then Section 74 exists to say, I don't think that was a good enough reason. That's sort of how that tension is created in the court. A registration certificate shall be revoked by the Registrar of Firearms if the registrar is informed by a chief firearms officer that the firearm is not being used for a purpose described in Section 28 of the Firearms Act. So they shall revoke it if you're not using it for what you said you're using it for. So if you say, I am buying these guns because I'm target shooting, and instead you're using them to, deal drugs or something like that, then they are supposed to revoke your license. And that makes sense. A registration certificate is automatically revoked in relation to a pre-August 1, 1992 converted firearm on the change of any alteration in the prohibited firearm that was described in the application for the registration certificate. So those are converted full auto firearms. If you have a firearm that is converted from a fully automatic firearm to a semi-automatic firearm, and those are banned. However, some people are grandfathered in. If they had one prior to August 1st, 1992, they might be grandfathered. But if you have one of those grandfathered firearms and you change it back to full auto, then the registration certificate is automatically revoked and it's illegal for you to have that. It's also illegal for you to make that alteration. So there's all sorts of crimes that come up if somebody does that. And oddly enough, it just doesn't come up because anybody who's had a firearm since 1992 without committing a crime with it probably isn't going to change their mind anytime soon. So a registration certificate is automatically revoked by operation of Section 116 of the Criminal Code when the person to whom the registration certificate was issued is made the subject of a prohibition order under the Criminal Code. So if you are banned from having guns, it automatically cancels all of your registration certificates. If the prohibition order is issued under Section 515 of the Criminal Code, the judicial interim release provisions, then the registration certificate is revoked only in respect to the period during which the order is in force. So judicial interim release is another word for bail. If you are out on bail conditions that provide for you to, not have guns in the interim period, which lots of bail conditions do. If you're accused of robbing a bank, they're not going to say, hey, and it's okay for you to keep your guns in the meantime because, no, obviously not. But in that case, it's only during the order is being enforced, which means until your trial or until the charges are somehow dealt with. At which point, if you're convicted of robbing a bank, you're almost certain to get a firearm prohibition that then kicks in and bans you for whatever period. But if you're acquitted and they say you're not guilty, you didn't do it, then the order ends and you can potentially go and get your guns back. A registration certificate expires when the person holding the registration certificate ceases to be the owner of the firearm or the firearm ceases to be a firearm, and that's provided in Section 66 of the Firearms Act. The Criminal Code in Section 114B refers to surrendering documents, such as registration certificates, but that relates to surrendering the physical document if a prohibition order so directs. A registration certificate may only be issued for a prohibited firearm or a restricted firearm, Section 12(1) of the Firearms Act. And that was because the long gun registration has been canceled, which is good because it means I have less useless paper to keep around. A registration certificate is issued to the owner of the firearm specified in the registration certificate. A person is not eligible to hold a registration certificate for a firearm unless the person holds a license authorizing the person to possess that kind of firearm. This is the section that the Attorney General is saying is doing a lot of heavy lifting, because they're saying if you're not eligible, that it must be automatically canceled. Now, I don't see how that can come up, because not eligible also comes up in other scenarios. So we'll see Section 13 speaks of a person being not eligible to hold a registration certificate unless that person holds a license authorizing the person to possess that kind of firearm. Section 13 makes no reference to the validity or existence or revocation of the registration certificate if the person holding it is not eligible to do so. Section 13 simply addresses the eligibility of the person to hold a registration certificate. Now, the not eligible language is used elsewhere in the Firearms Act. For instance, if they think you are a danger to yourself or others, then you are not eligible to hold a firearms license. But they have to bring a revocation proceeding in that case. That is the sort of textbook situation where they'd bring a revocation proceeding. So if this not eligible to hold language means that it's just automatically canceled, then Section 74 effectively just vanishes entirely in a puff of smoke, because the only reason they'd revoke your registration certificate is if they think you're not eligible to hold one. That's kind of the key thing there. If not eligible, in the opinion of the registrar, means that it just goes away automatically, Section 74 is imaginary entirely. So likewise, the regulations do not speak of registration certificates at all. They're not mentioned in the regulation. The regulation simply reclassified certain firearms from non-restricted or restricted to prohibited. The only effect the regulations had in relation to the registration certificates, i.e. the registration certificates which had previously been issued in relation to the firearms, the classifications of which were now changed, was to change the eligibility requirements in relation to holding those registration certificates. After the regulations, in order to be eligible to hold the registration certificate for the now prohibited firearms, one must hold a license authorizing one to possess a prohibited firearm. The regulation did not purport to do anything, nor did it do anything to the registration certificates themselves. Read in conjunction with Section 13 of the Firearms Act, the regulation affected only the eligibility to hold the registration certificate. Again, I agree entirely with this reasoning. This is 100%. Did the regulations reclassification of a firearm from restricted to prohibited result in the revocation by operation of law of the registration certificates previously issued for that firearm? It is on this point that Barrett and the Registrar of Firearms is of assistance. So in that case, and maybe I should cover that case, I don't think I've covered that case, I'll have to check. Ms. Barrett obtained a firearm acquisition certificate in February 1995. Later, in 1995, Ms. Barrett acquired registration certificates for 2 handguns. Those handguns were, at the time, classified as restricted firearms. At the time, no license was required to lawfully possess the handguns. The FAC was needed to acquire the handguns. So, I never held an FAC. I came to gun ownership a little later. I would have been not that old in 1995. However, many people I talked to did hold FACs, and FACs, the previous FAC system, you needed a license to get a gun, but once you had it, you didn't need a license simply to continue having it. So if your FAC expired, you could still hold the guns you already had, unless something was banning you from having those guns or requiring them to be taken away. So on December 5th, 1995, the Firearms Act, which replaced the Criminal Code as the legislation which controlled the registration and regulation of firearms, was given royal assent. Most of its provisions came into effect on December 1st, 1998. Under the new legislation, it became necessary to have both a registration certificate and a license to possess firearms, such as the ones possessed by Ms. Barrett. The license requirement was new, and previously issued FACs were deemed to be a license to possess firearms. So that's part of... There's always transitional provisions when there's laws. So when they're updating a new law to, from an old law, they usually have provisions to provide for people who were complying with the old law to make sure that they're not going to get sort of stuck with the changeover. So those might be delays in implementation. And those might be, in cases like this, situations where your old license is deemed to be a new license, at least until such time as you've got an opportunity to get a new license. So, however, Ms. Barrett allowed her FAC to expire on February 10th, 2000. Further, under the provisions of the Firearms Act, all registration certificates previously issued under the Criminal Code were deemed to expire on December 31st, 2002. Ms. Barrett applied to renew her registration certificates in October 2002. In 2008, she learned that her application for registration certificates had been refused. She applied to refer the decision of the Registrar of Firearms to a judge of the Provincial Court of British Columbia. While successful at the Provincial Court, the Attorney General's appeal was allowed, and ultimately, Ms. Barrett was unsuccessful in obtaining a registration certificate for her now prohibited firearms. However, what is relevant to the matter at bar is that Justice McEwen was of the view that Ms. Barrett's registration certificates continued to exist up to their expiry date of December 31st, 2002, which was long after Ms. Barrett was no longer eligible to hold those certificates because her FAC, deemed license, had expired, and long after her firearms had been reclassified as prohibited. Justice McEwen said, "It is not, strictly speaking, correct to speak of Ms. Barrett's right to keep a prohibited firearm. She is only permitted to possess such a weapon if she's authorized by the legislation to do so. On the face of it, she was not, because the legislation requires the owner to be licensed and the firearm to be registered. Because Ms. Barrett's deemed license, the FAC, had expired on February 10th, 2000, she was not eligible to hold a registration certificate. By the time Ms. Barrett's registration certificate expired on December 31st, 2002, she had been ineligible for over 2 years." So what the court is pointing out here is that in that case, they didn't say that the registration certificates just magically vanished by operation of law. They said that she continued to hold them up to their expiration date, even though she was ineligible. It is also interesting to note that Parliament must have taken the view that the registration certificates which had been issued for restricted firearms still existed after the reclassification of the firearms as prohibited. If Parliament was not of the opinion that the registration certificates existed after reclassification, then it would not have been necessary to set an expiration date for those registration certificates. And I think that one is a zing, because that shows that Parliament clearly thought that they continued to exist. The Attorney General disagrees that Barrett is of any assistance, given that the British Columbia Supreme Court was dealing with deemed registration certificates, which had carried over from the statutory scheme that preceded the Firearms Act. And those deemed registration certificates, again, are part of the transitional provisions that only really mattered during the changeover from the FAC system to the new PAL system. With respect, the Attorney General misconstrues the relevance of Barrett. So they're saying either they're, misconstrues sort of implies that they're suggesting it says something that it doesn't. It's not suggesting that they're behaving improperly. People have different opinions on law, but it can also suggest that they maybe misunderstand it. While factually quite different from the case at bar, the narrow relevance of Barrett is simply to demonstrate that after reclassification of firearms, the registration certificate still existed. The reclassification of the firearm did not revoke the registration certificate. And we can see that quote from Barrett noted that disjunct, where Miss Barrett had a registration certificate, but she was still not legally in possession of those firearms. So that quote from Hewlett is incorrect if you take Barrett as a correct statement of law. One of those cases has got to be wrong. So from all that, we can take that the registration certificates held by Mr. Crawford did not cease to exist on May 1st, 2020, upon making of the regulations when his firearms were reclassified as prohibited, even though as of that date, Mr. Crawford would no longer have been eligible to possess a registration certificate for those prohibited firearms if he did not hold a license to possess prohibited firearms. The Attorney General submitted that the registration certificates issued in relation to Mr. Crawford's firearms became invalid when the firearms, previously classified as restricted, were reclassified as prohibited. The Attorney General pointed to the registration certificates and noted that each certificate at the time of its issuance referred to the class of firearm as being restricted. This submission was that the registration certificate no longer applied to the firearm once it was reclassified as prohibited. the act of reclassification made the registration certificate invalid. So the argument here is that because your registration certificate says restricted on it, once the gun changes to a prohibited firearm, that registration certificate no longer applies to it. But that's kind of an interesting thing, because what happens if you get a certificate that just contains some sort of typo or says, that the barrel length is something and you change it? The law actually proposes that you might, it actually considers that you may change some elements of your gun that then refer to, that are on the registration certificate. You might have it rebarreled. You might have it all sorts of things. There's a requirement that you report those changes in within a certain period, but that doesn't say, if your registration certificate suddenly instantly no longer applied, you would be in some serious trouble at that point. So that's a bit of a big deal. So I don't think that this can be correct, their position, when you take those other things into account. If Parliament had intended that the reclassification of a firearm would not only affect the eligibility to hold a registration certificate for that firearm, but would also revoke any registration certificate previously issued for that firearm, it would have done so by stating that if a firearm classified as restricted is reclassified as prohibited, then any registration certificate previously issued in relation to that firearm is automatically revoked. Parliament was well aware of the concept of automatic revocation. So, because they've actually put automatic revocation into the law, they clearly have an idea that this is a thing that might be necessary at some points. For example, in Section 71(2), Parliament decreed that a registration certificate is automatically revoked upon the happening of events described in that subsection. The same concept of automatic revocation was employed by Parliament in Section 116 of the Criminal Code. Having specifically used the tool of automatic revocation of registration certificates on 2 occasions, it is artificial to infer that Parliament intended that automatic revocation of registration certificates was to be implied when firearms were reclassified from restricted to prohibited, particularly since, under the legislation, such a reclassification only affects the eligibility to hold a registration certificate. I think that this is a powerful paragraph right here. They basically say, listen, Parliament uses automatic revocation, but they don't use it here. And so why are you telling me that automatic revocation applies here when we see it applies in this other place and it applies in some other place, but they didn't write it in here? Are you writing it in for Parliament? Because if so, you're in the wrong chair. You're there as the Attorney General of Canada. Maybe you should be an MP if that's what you're trying to do. So I think this is a really, really good paragraph. I think this is solidly written, solidly reasoned. I am going to be interested to see how other courts deal with Fradsham Part 2, Fradsham Strikes Back, because I think Judge Fradsham comes out swinging with some really powerful reasoning and argument here. The Firearms Act and the regulations under it created a regime in relation to the acquisition, possession, transportation, storage, and use of firearms. Within that regime, there are provisions under which the Registrar of Firearms may, and sometimes must, revoke a registration certificate for a firearm. The regime created by Parliament does not envisage or authorize, nor does it need to do so to achieve its purpose, revocation by implication. So, again, this is saying, this revocation by implication concept is one that is just imaginary. It's not in the law. It's not stated anywhere. You're making it up. And yeah, sometimes the worst thing is a case, like when you find a case that agrees with you, but it's really not powerfully reasoned. But I really like this one because this case goes through a lot of effort to set out why and how it gets to where it's going. So I love that in a decision, and especially when it's a decision that agrees with me. But as a lawyer, you have to be able to look at both, just because you like the conclusion of a case doesn't mean that the reasoning for it is necessarily going to be helpful. This one, I think, is really well done. The next logical and fair question is, what is to happen when a person who is eligible to hold and does hold a registration certificate for a restricted firearm finds him or herself possessing a firearm which has been reclassified from restricted to prohibited, and as a result of that reclassification, the person is no longer eligible to hold the registration certificate for that firearm because he or she does not hold a license authorizing his or her possession of that kind of firearm. The answer is that one of two things can occur. One can infer, read into the legislation, that the registration certificate held by the person is automatically revoked. Or two, one can simply look at the existing provisions of the Firearms Act and note that if the Registrar of Firearms concludes that the person holding the registration certificate is no longer eligible to hold that certificate, then the registrar may rely on his or her express powers to revoke the registration certificate for what the registrar concludes is good and sufficient reason. And so there's two options for how the courts could interpret this. A lot of courts have held number one, that it's just automatically done. But number two is the one that seems to actually be written into the Firearms Act and how the Firearms Act is intended to work. So let's carry on here. This is going to be a long video. I'm sorry. I know a lot of people don't like the long videos, but this is a really important case for gun owners across Canada, so I really want to cover it. In the interpretation of legislation in Canada, the learned author states, assuming a statute to be well drafted, any interpretation which adds terms or provisions or deprives terms or provisions of their meaning or utility should be considered dubious. Since the judge's task is to interpret the statute, not to create it, as a general rule, interpretation should not add to the terms of the law. Legislation is deemed to be well drafted and to express completely what the legislature wanted to say. So there's a lot in this paragraph, and this is from a textbook. So first, there is a presumption that Parliament knows what it's doing when they're creating a statute and that they've put a lot of care and attention into it, that the language didn't happen by accident, that where there's a linguistic choice, that it means something. All of these are provisions, and you might disagree because sometimes Parliament doesn't seem to be doing the best job. But in terms of actually making the law work, the law cannot function if the assumption is that Parliament are a bunch of screw-ups and everything just needs to be rewritten as soon as it hits the court. That it would be a big problem because we have different powers are given to different elements of the government. And if you view the courts as sort of a governmental organization, and they're sort of they play a pseudo-governmental role, but they're kind of removed from government in a lot of respects. But the judge's job isn't to make law. The judge's job is instead to say, this is what the law that Parliament has given us does. We're to interpret and apply it. So Parliament makes the law, the judges apply the law. What happens if they start reading in new provisions or striking out provisions is that the judges are effectively at that point stepping into the roles of lawmakers, and that is potentially a big problem. So they say, if we presume that a statute is well drafted, and we do, and if this essentially adds new terms to the law, this is a problem. This should not happen. That's kind of what this paragraph is stating. And this is an incredibly important concept in legal interpretation. Judges are not supposed to be fixing problems with the law, even. The Supreme Court, in a case that I probably will never cover because the facts on that one are incredibly ugly, but the Supreme Court has basically said, if there's a problem with the law, the court is not the one to fix it. The court is to say, hey, listen, the law doesn't do what you think it's supposed to do. You fix it. So continuing on. The learned author further explained, the presumption against adding words must be treated with caution because legal communication, like all communication, contains both implicit, the overall context of the enactment, and explicit, the actual working elements. The presumption only concerns the explicit element of the legislature's message. It considers that the judge who adds terms to a provision legislates and usurps the role of the legislature. However, if the judge makes additions in order to render the implicit explicit, he or she is not overreaching their authority. The relevant question is not whether the judge can add words or not, but rather if the words added do anything more than express what is already implied by the statute. So this is kind of more finicky, but basically says it's not necessarily a problem if they're adding words so long as it's getting to what the legislation is trying to do. But once they start adding new things that the legislation does, that becomes the problem. So in Bristol Myers Squibb versus Canada, the court said at paragraph 103, the courts must be careful not to confuse policy considerations leading to the adoption of an act or regulations, which are examined in order to discover legislative intent, and the appropriateness of policy choices, which are a matter that must be left to legislators. Contextual interpretation does not justify departures from ordinary rules of statutory interpretation. In particular, reading in words cannot be justified in the absence of a demonstrable ambiguity. In the case at bar, the automatic revocation of a registration certificate when the firearm to which it relates is reclassified as prohibited is not implicit in the legislation. That is so because the reclassification only affects that which is necessary to make one eligible to hold the registration certificate. If the holder of the registration certificate also holds a license permitting that person to possess the reclassified firearm, then no revocation is appropriate. If the holder of the registration certificate is not the holder of the required license, then the registrar has the power under Section 71 to revoke the registration certificate. It is simply not necessary, in order to give full effect to the intent of the legislative regime created by the Firearms Act, to judicially add a provision of automatic revocation of a registration certificate upon the reclassification of the firearm to which it applies. Parliament could have done so if it wished, but was obviously content to rely on the explicit revocation powers already granted by the legislation to the Chief Firearms Officer, and also to the Registrar of Firearms. That's me adding in, but they both have revocation powers to their respective areas of authority. In short, I'm of the view that one should interpret the applicable sections of the Firearms Act as written because such an approach will fully achieve the intent of the legislation. That is preferable to an approach which resorts to reading words of revocation into Section 13 of the Firearms Act when 1. The power to revoke is already available to the Chief Firearms Officer, and 2. Parliament, which was obviously aware of the concept of automatic revocation, having used it in other parts of the legislation, chose not to use it in cases of firearm reclassification. As noted, I am mindful of the judicial opinions which, on this issue of the effect of the regulations, disagreed with my decision in Stark. However, upon further reflection, I arrive at the same conclusion as I did in Stark, and therefore must respectfully disagree with those contrary opinions. So the judge is sticking to his guns. He says, I've heard you. I hear that you're saying I'm wrong, but I'm not wrong. I'm right. I disagree with your contrary opinions. The Attorney General, relying on the obiter reasoning set out in Canada and Whitmore, and obiter is the non-binding parts of a decision. It means sort of by the way. So a court case may have binding elements as well as judicial commentary. And that judicial commentary is obiter. It can be helpful for future courts, but it doesn't tie the hands of future courts. Also submitted that Section 74 is not available to Mr. Crawford because the Registrar of Firearms did not make any decision in relation to Mr. Crawford's firearms. The Attorney General submitted that revocation requires the exercise of judgment or discretion in light of particular facts, quoting from paragraph 35 of Whitmore, and that the Registrar of Firearms was not engaged in that function when he or she sent out the letter of July 20th, 2020. I respectfully disagree. I'm of the respectful view that what is described in Canada and Whitmore, exercise of judgment and discretion in light of particular facts, is one way how a decision can be made. However, a decision, which is what results when the registrar decides to revoke a registration certificate, is a choice or judgment made after considering something. And they quote a particular dictionary. A decision is no less a decision just because the decision maker sees no alternative. The imposition of a mandatory sentence of life imprisonment for first-degree murder is no less a decision because it is mandatory. From a lawyer's perspective, boom. Like, that is a mic drop moment because clearly a court is making a decision when they impose a sentence. And there's all sorts of situations where the court may say, I have to make this decision because it's mandatory, and it still gets appealed. And sometimes those appeals are grounded. So consequently, if the registrar believed he or she had no choice but to decide to revoke Mr. Crawford's registration certificate because of the regulations, the revocation is still the product of the registrar making a decision. However, even applying Whitmore, the registrar made a decision. In sending the letter dated July 20th, 2020 to Mr. Crawford, the Registrar of Firearms was expressing his decision that the registration certificates belonging to Mr. Crawford were automatically nullified and are therefore no longer valid. Part of the decision made by the Registrar of Firearms was as to the legal impact of the regulations on the registration certificates held by Mr. Crawford. Furthermore, when the Registrar of Firearms sent the letter dated July 20th to Mr. Crawford, the Registrar had decided that the regulations applied to the two specific firearms and registration certificates listed in the letter. The Registrar considered the particular information available to him and concluded that the firearms noted on registration certificates, and they list the numbers, were firearms that were included in hundreds of firearms listed in the regulations. Their inclusion in the firearms listed is not evident simply by reading the list. The registrar made an individualized decision in specific reference to Mr. Crawford's firearms. Again, this is a well-articulated and I think fairly straightforward and somewhat obvious element. The registrar is saying, listen, I think that these two guns are, over 10,000 joules, or that they are, AR-15s, or that they're Mini 14s, or whatever the registrar thinks is the reason why they need to be, why they are properly a prohibited firearm. But the registrar has examined the regulations and examined the information that's available to them and made a decision that these two things match. So that has to be a decision. It isn't that there is some, angelic being that comes out and just says, lo and behold, this is the list. These are the... Somebody has to sit there and say this particular gun is one of the guns that is banned, and therefore that this applies to them. So that has to be a decision. How can it not be a decision? So in Canada and Stark, I explained why I concluded that the contents of the July 20th letter constituted a communication to its recipients that the Registrar of Firearms had decided to revoke the registration certificates particularized in the letter. I will not repeat that explanation, but I do rely upon it. The Attorney General submitted that even if the Registrar of Firearms had revoked Mr. Crawford's registration certificates, Mr. Crawford's Section 74.1 review application should be struck out because no meaningful remedy is available to Mr. Crawford, and that, in those circumstances, the hearing of the application is a waste of judicial resources. The Attorney General submitted that by virtue of Section 8.2 of the Provincial Court Act, the court may apply Rule 3.68 of the Alberta Rules of Court, which says, if the circumstances warrant and a condition under Sub-Rule 2 applies, the court may order one or more of the following. I know this is dense, I'm sorry. That all or any part of a claim or defense be struck out, or that a commencement document or pleading or amended be amended or set aside. And the conditions include that it discloses no reasonable claim or defense to a claim, a commencement document or pleading is frivolous, irrelevant, or improper, or it constitutes an abuse of process. So, examples of no reasonable claim would be, let's say I sue you because I say that your face is ugly and that this is causing me stress. That is not something that I have a claim for. Nobody gets to... There is no recoverable money for that. Or let's say I sue you because I say that my business failed because you thought bad thoughts, and you never did anything, but you thought bad thoughts against my business. Again, that's not a reasonable claim. No court is ever going to grant a judgment in that favor or on that basis. So that would be an example of something getting struck out for no reasonable claim. You might also have no reasonable defense. Let's say you ran me over with your car and you file a statement of defense that says, yes, I ran over Mr. Runkle with my car and I did so because I hate his YouTube videos and I really wanted to hurt him. That's not a defense to the claim. That is an admission to the claim. And so they would say, listen, you don't actually have a defense. So these are sorts of examples of situations where the court can say, we're just going to strike out these things and get on with the court decision. So the court says, I agree that Section 8.2 of the Provincial Court Act makes this rule available to the court, and they cite Parker and Menzies Field Mechanical Services. However, I do not believe that Rule 3.8 or 68 sub 2 can be used to circumvent a review remedy granted by a statute. It is the Firearms Act which grants the right to seek in provincial court a review of a decision of the Registrar of Firearms to revoke a registration certificate. The Firearms Act provides, inter alia, that a person who has had his or her firearm certificate revoked by the Registrar of Firearms may seek a review of the decision in provincial court. Rule 3.68 does not provide an avenue for the Attorney General to have the review application struck before any evidence is tendered in the review, on the basis that the Attorney General sees no way for the review to be successful. That is, in effect, an attempt to use Rule 3.68 to obtain a summary dismissal remedy without complying with Rule 7.3. If at this stage Rule 3.68 sub 2 does apply, then I'm of the view that Mr. Crawford's Section 74.1 review application does not give rise to any of the conditions set out in the rule. On the issue of whether Mr. Crawford's review application is frivolous, irrelevant, improper, or constitutes an abuse of process, I note that in both Hewlett and in the matter of an application to obtain a production order pursuant to Section 487.014 of the Criminal Code of Canada, the learned judges concluded that the regulations had revoked the registration certificates. However, the submissions of the Attorney General before me in their applications to strike the review applications disclose a less definite view. I will review the changing content of those submissions, not as any form of criticism, which it is not, but for the purpose of showing that the legal issues which Mr. Crawford had to consider when filing his review application were, and are, the subject of some dispute in legal circles. So he's saying, I'm not bashing the Attorney General. They're entitled to kind of amend their position. They're entitled to roll with the punches and to say, like, this court has said, you know, this argument works better and this court doesn't like that argument, so we're going with the arguments the courts like. That's kind of expected, right? You'd expect people, when they're bringing further applications, to drop the ones the courts say are not so good, and to focus more on the ones the courts say are good. So that's not a criticism. That's just saying things are changing, things are happening. This is what a good lawyer does. It's necessary, it's appropriate. So in Stark, during submissions, counsel for the Attorney General said of the registration certificates, the certificate still exists, absolutely. We don't dispute that. Counsel was later asked, and when the registrar says they are a nullity, do they still exist? The answer was, so that's an interesting point. So in a legal sense, no, they do not. But in a historical sense, they're an important document, and the reasons they're an important document in a historical sense is under the amnesty order. So later, counsel for the Attorney General said, and under that legislative framework, a registration certificate can only exist if it exists with respect to a firearm that a person can lawfully possess. And so, when that person ceases to be able to legally possess that firearm, that certificate, in the legal sense, ceases to exist. That's the nullification. Now, speaking frankly, could the letter have been worded better with respect to what had happened? Yes, it probably could have been, but the reality is that that doesn't, in and of itself, create a decision where discretion was exercised by the registrar. Nor does it create a situation where the registrar could have exercised a discretion to make a decision because, in effect, what use is a notice of revocation for a certificate that has already become invalid by the change in regulations and the ordinary operation of the section? Counsel for the Attorney General was asked these questions and gave these answers. Court, if I understand the Attorney General's position, it is that which was done by the Governor and Council was not a formal nullification, just what it did had the effect of nullifying. That's correct. Effectively, yes. And if it effectively nullified, it effectively revoked. Counsel, if that's how the court would like to characterize it, I think that's not entirely inaccurate, but again, I'm cognizant of the fact that there is litigation before the federal court with respect to what the Governor and Council did or did not do, and I'll be honest, I don't know what impact that could have, if that makes sense. So I'm not prepared to make that admission before Your Honor, but in effect, yes, our core argument is that the decision here was the decision of the Governor and Council, and that is what is what has changed the legislation which impacted Mr. Stark's rights. The registrar had no decision to make here with respect to the letter that was sent. Later, in a subsequent proceeding, Canada and Dare, counsel for the Attorney General made these submissions. And so this is Mr. Cherokee, and again, acknowledging that the applicants weren't here when we argued Stark, You actually posed a very interesting question to me, Your Honor, during the Stark proceeding, which is, if the registrar didn't revoke these, are these certificates revoked? It is our position they're not. The term nullification is used in the letter, but perhaps invalidation is a bit more on the nose or on point. The letter, I guess, could have been clearer, but the registrar's letter essentially informs the applicant that because of the OIC, their previously held registration certificates for restricted firearms no longer permitted them to possess those now prohibited weapons outside the scope of the amnesty order. It also informed those applicants about the various steps the government is currently considering, including a buyback program. So it was an informational letter that is effectively the document that the applicants are collectively trying to refer to this court. They're saying it doesn't do anything, it's just information. But yeah, continuing on, this is another quote from counsel. There's an interjection here, so this is a later quote. So if the certificates aren't revoked, what are they? Essentially, they're certificates that are no longer valid in the sense that certificates themselves can only attach or provide privileges with respect to restricted firearms. If the certificates themselves say they need to attach to a specific firearm classified as restricted. Once the classification of that firearm changes to prohibited, that certificate no longer authorizes the individual to continue to lawfully possess them. But even if there is, in the court's view, a revocation or a nullification, or however you would like to put it, that happened because of the OIC, because of the decision the governor and council made. So there are two basic components you need to have. You need to have a revocation, and that revocation needs to have been made by the registrar. And in our view, neither of those criteria are met on the basis of these cases. Court. So this is the judge, and I think this was Judge Fradsham here when they say the court. You said revocation and nullification, however I wanted to put it. The registrar put it nullification. Mr. Froke, yes. The court, yes, it is a nullification, the same as a revocation. Mr. Froke, no, in our respectful submission, it is not. The court, what is the difference? Mr. Shiroki, well, I understand there was a colleague of mine that was involved in the drafting of that letter somewhere in another DOJ office, and I don't know why the word nullification was used. And I agree that the letter could probably have been worded a bit more clearly. But a revocation is, under the Act, a specific kind of decision that the registrar makes under Section 71. And this is getting kind of technical here, isn't it, folks? I mean, when we're talking about this, they're basically saying, listen, both decisions end up with your registration certificate being canceled and no longer being in effect. But this is grape decision and not lime decision. Well, they're both kind of the same thing, right? They're both whatever they are. So, Mr. Shiroki, and so had the intent for it to have been a revocation, so there are 2 points I'll make here. Had the intent for it to have been a revocation, the word revocation would have been used. And I'll just interject there, or maybe the word revocation wasn't used because the intent was to cancel the certificate without people being able to bring these challenges. If the court allows them to do a linguistic dodge, it basically just means that how you phrase your letter determines whether or not somebody can sue you. I did the thing, but I didn't use the word for the thing, so this starts sounding like some arguments that the courts have thoroughly rejected, and so thoroughly rejected that I'm not even going to be more specific than that. Yeah, I don't like this kind of linguistic sort of maneuver. And in fact, the courts have, in cases like Evers, taken a pretty strong view of this kind of language. We can't, you can't bring this under a Section 74 because we didn't issue you a formal revocation. The courts haven't had a whole lot of time for that. So, but even looking at the decision itself, it is not in substance a revocation. So let's say, and again, this is something that came up during the Stark hearing, which is the question of, is this some sort of surreptitious attempt to make a revocation without calling it that to subvert Section 74? That is simply not the case on the facts here. I'm not so sure. I mean, we have seen the Evers case. We've seen the Belofsky case. We've seen the Runkle case. There are several cases where the courts have kind of suggested that there was a surreptitious effort on previous similar decisions. So it's like if somebody breaks into my shed 3 times and then I find them there a 4th time and they say, listen, I got lost. I was on my way to the bank and turns out I'm in your shed again. How does this keep happening? I don't know that I agree with that. So the form of the letter isn't, here is a decision that I've made. Here are the reasons why. It is, here is the change that has been made to the classification regulations. Here are the firearms that you possess certificates for that it affects. Here is the substance of those effects that the change in legislation has done. Here's what the government of Canada is doing with respect to a buyback program. It is informational. So in substance, this nullification or the information letters, as we put in our submissions, is not a revocation. It is not even a decision from the registrar. The court, right, but are you saying that it is a nullity, that this purported decision to revoke is a nullity because there's nothing to revoke? Mr. Shiroki, that's essentially correct because the validity of the certificate changed when the order in council came into place. The court, so if there's nothing to revoke, is that because the order in council revoked it? Mr. Shiroki, that would be a question for the federal court. Again, we're dealing with respect to just the question that we're here in front of this court to answer, which is there a decision of the registrar such that we can trigger Section 74 to hold a reference hearing? As soon as the question becomes, what decision did the governor and council make, we're already outside of Section 74.1. And maybe I'll finish just this section and then I'll come back to that. So the court, well, not in your argument, because your argument is that the order in council did something and therefore Section 74 does not apply. I cannot figure that out until I know what the order in council did. Mr. Shiroki, so what the order in council did is change the classification of the certificates, the firearms, which in turn impacts the validity of the certificates. And furthermore, it impacts, under the Firearms Act, each individual applicant's ability to continue to possess or obtain registration certificates for the newly prohibited firearms, right? So at that point, when the order in council comes into effect, the certificates become these historically important evidentiary documents. So just to... the one thing that keeps coming up is that there's actually 2 decisions. And I know that the government's position has been that there's only one decision. It's the government, the government in council, or the governor in council makes the one decision and that revokes, and then nothing happens after that. But I think this case illustrates, and just common sense says, that there are 2 decisions. The first decision, of course, is the governor and council's decision to ban a list of things. But that second decision is to decide that this particular gun held by this particular person with this particular registration certificate number is a gun that meets those criteria. For instance, let's say the government decided to do something really unusual and they said, we are going to ban all pink guns. And any gun that is pink is now a banned firearm. You can't have it. That color is reserved exclusively for whatever. So let's say that you then go and you get a notice saying, hey, we are aware that your gun is pink and therefore we've canceled the registration certificate. But let's say you'd actually painted it blue and, it's never been pink. It's a blue gun and somehow they think it's a pink gun. That's second decision. That decision that your gun is the pink gun is its own separate thing. There's 2 decisions here, and the court gets led into error if they're told that it's just one decision. It's actually 2. Continuing on here. Court, well, it is just that you have told me that the order in council did not, you've told me that the registrar did not revoke, and I get that, and you've told me that the order in council did not revoke it, so I'm just wondering then, after the order in council, was it possible for the registrar to revoke it? And Mr. Shiroki says, so the hesitancy for me to confirm this, and I'm content to know that my colleagues have the same opinion, is that essentially after the order in council, these are invalid certificates insofar as they are certificates that grant a privilege under the Firearms Act outside of the amnesty order. The court, right. Mr. Shiroki, so I guess my answer would be that because they're now invalid, there's really nothing to revoke. So the answer would be no. Concurrent with the Attorney General's application to strike Mr. Crawford's review application was an identical application by the Attorney General to strike a review application brought by a Mr. Goodman. In both the Goodman application as well as the application at bar, I had the benefit of submissions made by a different lawyer appearing for the Attorney General. And there being a different lawyer isn't, some people might say, oh, why do they have 2 lawyers? Well, because the Attorney General has lots of lawyers, and across Canada, certainly you're not going to have one lawyer appearing on every one of these files across Canada. That would be nuts. But even just within Canada, and even within sort of narrow jurisdictions, they're going to need multiple people for multiple places. It gets complicated. So this isn't something, untoward. Nobody should be reading anything shady into this. This is 100% boring that there's more than one lawyer. The only thing that is interesting here is that it's going to illustrate that there are different positions taken by the Attorney General. And, again, that doesn't indicate that anybody here is wrong. And I'm certainly not attacking any of these lawyers here. They're presenting the positions of their clients, which is their job. And I may disagree with the positions taken by their clients, but that doesn't mean that the lawyers are doing something improper or anything else. They're doing the best that they can with what they've got. That's kind of what law is about. Sometimes you have to run with something that maybe isn't the greatest, or maybe other people disagree with. It could turn out, when this case is eventually all said and done, and I've said before, and I will say again, I think it's going to end up in the Supreme Court. It could be that the Supreme Court says Mr. Runkle was wrong about all of this, and then I'm going to have to probably make a video saying, turns out I'm wrong, Supreme Court says I'm wrong. So, yeah, I'll continue on here. Ms. Furlong, if a person does not have a license for a particular class of firearms, they are not eligible to hold their registration certificates. And by virtue of Section 13, Mr. Crawford and Mr. Goodman are no longer eligible to hold their certificates. Sorry, when you say that Mr. Crawford and Mr. Goodman are not eligible to hold a certificate, that may be a reason for the registrar to revoke their certificate, but it doesn't go to the question of whether the certificate ceases to exist. Ms. Furlong, yes, sir. I find, as I'm sure you're very aware, sir, that the semantics of the case in terms of wording is very challenging sometimes. That's an understatement. The Firearms Act is not written in a clear fashion. And I would say, sir, in Barrett, we can see that the court says that the registration expired. The wording, as you know, is challenging, whether it expired, whether it is nullified, whether it is invalid. The point that I'm making, sir, which you know, is that the certificate cannot be used in the same way. It cannot remain valid because they do not have a license to be able to hold a certificate for that classification of firearms. It's something other than valid. And I'm going to interject to say I disagree with this. It's possible that you hold a valid certificate. It just doesn't let you do anything because you need two things to do anything with the certificate. You need both the prohibited firearms license, that allows you to hold that particular class of prohibited firearms, and you need the certificate. And saying, listen, you don't have one thing doesn't mean you don't have both things. It just means, so saying it's no longer valid because you wouldn't be able to possess the firearms, I don't see how that follows. It just says you don't have one thing that is necessary of this two-part thing to possess it. Those are separate legal concepts and constructs. So the court continues on. Okay, does this go back then? And I'm looking at your brief. I'm referring specifically to the brief you filed with respect to Mr. Goodman, but I believe the numbering may be the same. I'm looking at paragraph 26, and you refer to the Newfoundland case of H in Canada, and you quote a paragraph from that decision. I'm now flipping over to page 8 of your materials, and this is Judge Gorman speaking, and I covered that decision previously. Section 74 of the Firearms Act allows a provincial court judge to hear a reference only if a registration certificate has been revoked by the registrar or a chief firearms officer. In this case, that did not occur. Mr. H's registration certificate was canceled, revoked, or nullified by legislative action. So I take it that this is the position of the Attorney General today, is that the Order in Council revoked the registration certificate. Ms. Furlong, our position, sir, is that the Order in Council obviously changed the registration certificates, and I don't know if we would adopt the same terms the judge in H in Canada, that it was revoked. Obviously, our position was that it was nullified by legislative action or invalidated, but yes, the status of the certificate had to have changed because of the OIC. The court, well, as you say, words are important. When the Attorney General gives me this quote from the Newfoundland case, I gather that the Attorney General is backing away from the sentence I just read that Mr. H's registration certificate was canceled, revoked, or nullified by legislative action. Here, maybe I can put it more easily. Is that a correct statement of law or not? Ms. Furlong, yes, it is our position that that is a correct statement of law, sir. The court, all right, so if that is a correct statement of law, then the OIC revoked the registration certificate. Ms. Furlong, yes, sir. The court. All right, thank you. The court. I think my last question, although usually when I say that, I always find another one. There's a note. It goes back to the question of whether or not the order in council revoked the registration certificate. And there's a statement in the written materials. I'm reading paragraph 48 of your written materials. It starts with the phrase, unlike in Sherby. It states in the respondent's position now, the respondent is really the applicant because it is the Attorney General who is the applicant. So to correct that then, the Attorney General's position has always been that the registration certificates affected by the governor and council's decision are not revoked. Well, that flies in the face of what I'm reading in the decision of the Newfoundland court. You told me because the Newfoundland court said, yes, it was revoked. It just wasn't revoked by the registrar. If you're getting confused here, that's exactly what the court is pointing out, is just how confusing this mess has become with the different decisions and the different positions taken at different times. Ms. Furlong, yes, I understand your concern on the inconsistency there. What I can say is that my instructions are that the Attorney General's position is that the governor and council did not revoke it. It did something different. It invalidated it or nullified it. However, we are using H in Canada to support the position that the decision was not made by the registrar. I understand your concern there. However, those are my instructions on how to, I guess, give a term to the actions. The court, and I have great sympathy when a lawyer says his or her instructions are thus and so. This is not critical of you. I'm just trying to reconcile. I'm having difficulty reconciling paragraph 48 with the Attorney General's brief with paragraph 26. So when the court says, however, those are my instructions on, how, or when the lawyer says, those are my instructions on how to give a term to the actions, and the court says, I have great sympathy when a lawyer says his or her instructions are thus and so. This is kind of lawyer secretive language in court. And I'm gonna because when you say my client has instructed me to do something, this is actually something I try to avoid doing, because what it usually means is my client wants me to do something stupid and I'm doing it because my client has told me to do so. And I'm not saying that's necessarily what Ms. Furlong is saying here, but lawyers sometimes use this particular dodge. And I think it's a real problematic one, because I think there's a real problem if you are going into court and sort of waving a hidden flag saying, I think I have a bad position here, Your Honor, and, please don't hurt me for the bad position, but you should know I know that it's bad. The job of a lawyer is not to save your own butt in court. The job of a lawyer, and again, I'm not saying, this is a more general commentary and I see it in other courts. So I'm kind of on a digression here. I'm not trying to, bag on Ms. Furlong here, but it can sometimes mean that, you're trying to signal this to the court. I'm not the person who thinks that this is a good idea. My client is. And of course, once you tell the client, my instructions are, and I'm doing this dumb thing, you've decided the matter. Like, the court's not going to agree with something if you say, I think personally this is a bad thing. So I don't know if that's what Ms. Furlong is doing, but that is sometimes what the language is meaning. But it seems to be that is how the court is interpreting it. Because the court says, and I have great sympathy when a lawyer says his or her instructions are thus and so, which means that the court is saying, I read you, this is not really the position you would like to be taking. I don't know if that's what's going on, but it seems to me from a lawyer perspective reading into it that that's what's going on here. Maybe. And it's concerning But this is also concerning because if the instructions are to rely on this particular slicing of the language, then it seems to me we're getting into the Evers situation and the Belosky situation and the Runkle situation of them saying, we want to revoke or we want to refuse. We just want to use different language so you can't challenge it. This was described in the Evers decision as, playing as a game played. And this is kind of the stuff that this case is about, in my view, because if this is a situation of a game being played to avoid judicial review, the only way that stops is if the court says, listen, We've seen this before in Evers and Bolofsky and Runkle and all of these things, and now you're doing it on a national scale. Stop it. Like, this is what's at stake, is that it means that, if they can just play language games and pick a new word, like we invented a new word and now you don't get to challenge us, then that's very concerning. It's something that I think the court would have to stop in the most explicit and harsh kind of way. When you start thinking about what penalties get the government to sit up and take notice, they have to be pretty substantial. So I think that this concerns me. Anyway, again, I'm not trying to criticize the lawyers here at all, because I think that they're put into a tough position on all of this. But I don't think that their clients necessarily, I have some concerns about how their clients are behaving. We'll go with that. So, continuing on, but the bottom line is that contrary to what I thought I'd understood you to say earlier today, the registration certificate has not been revoked by anybody, either by the registrar of firearms or by the operation of the order in council. It has instead been canceled or nullified, but not revoked. Ms. Furlong, yes, sir, that's right. And I understand, especially given this court's conclusion in Imler and Stark, that revocation and nullification are one and the same. However, it is our position that the governor and council nullified and invalidated these certificates. The court, but didn't revoke them. That's correct, sir. In spite of what the Newfoundland court said. Well, as you pointed out, sir, we have inconsistencies in the brief between paragraph 48 and 26 on that. And I think what we can really take from H in Canada from our position is that whatever decision was made, it wasn't made by the registrar, it was made by the governor and council. You can see that, they're kind of a fish on the line. The court's got the lawyer here and is really digging into this point, and the lawyer doesn't want to get pinned down, because this is not a great place to be pinned down on this inconsistency. So the court, but it becomes important as to what it was. If the governor and council revoked, if the governor and council nullified, I have not yet been able to figure out what the difference between revocation and nullification is, and if you could help me with that, that would be great. Ms. Furlong, I wish I could, sir. We were relying on the word nullification because that was the word used in the letter, and we're trying to remain as accurate as possible as to what happened with it. It is our position that this is not equivalent to what would typically be a Section 74 revocation, which is a very different situation. It is difficult to characterize this because language does matter and the terms are very similar, but I think we have to look at the letter for that term and say, yes, the governor and council nullified or invalidated those certificates. So it appears that the only difference that I can see between those two words is that one of them gets you a Section 74 hearing and the other one doesn't. But otherwise, they do the same thing and they function exactly the same. So, yeah, that's a bit of a concern. The court. When Mr. Shiroki argued the matter of the files in front of me, one of the things he said was, because I asked him the same question, he said that the certificate in a legal sense ceases to exist. He said it ceases to exist. Does that continue to be... Ms. Furlong, I would say my position is slightly different than that, sir. As I pointed out earlier, the wording in the amnesty order and even what we discussed in our brief in the past, the certificate still has a purpose, and it even says in that letter the purpose is a historical record, and we provided an analogy to the court on our last application that it was like an expired passport, and while that analogy is not perfect in itself, it does, I think, give the court a sense of what those registration certificates can be used for. If we look to the amnesty order, it shows that they are important in showing whether someone is subject to the amnesty order and potentially, and as I discussed earlier, we can't predict what Parliament will do. But potentially, these documents will be useful in the grandfathering regime. As noted, I set forth these excerpts from the submissions made to me for the purpose of demonstrating that determining what effect the regulations had on previously issued registration certificates is not an easy matter. The Attorney General's position on the question has been the subject of some constant modification. Frankly, I do not yet find that position to be entirely clear. That one seems to me to be a little bit of a dig, but I don't think it's an unjustified dig after they go through and point out the sort of shifting language. Consequently, when Mr. Crawford filed his Section 74 review application, he was not engaging in mischievous, futile, irrelevant, or improper conduct. He was seeking a review which is available to him in law. He had a limited period of time within which to file his review application, and he did so while trying to determine the combined effect of the regulations and the registrar's letter, which, as can be seen, is a task which continues to perplex many of us, including the Attorney General. In this context, it is premature to say, before any evidence is adduced, that the review application is without purpose. I decline to strike Mr. Crawford's Section 74(1) review application under the provisions of the rules, and the application of the Attorney General to strike the Section 74(1) review application filed by Mr. Crawford is dismissed, which means it's going to go on to a full hearing on the merits. Now, there's a lot to this decision, which is why this is a super long video, and again, I'm sorry for that. But this is a really important and really well-phrased thing, and quite frankly, I now want to go through and maybe order some transcripts, because when you see the shifting in the language there, pulling those bits out of these transcripts indicates that the judge has put a lot of thought into this. And this is something that this decision would have taken a lot of care, because going through transcripts to find those quotes would have been something that takes a ton of work. But I like where the judge says, listen, this can't be frivolous because you guys are still figuring it out. And the Attorney General is, a powerful, when you think of the Attorney General of Canada, that's a powerful organization with a lot of lawyers able to, communicate with each other. I'm sure they've got, Slack or some other similar method of communicating with each other to, harmonize their position, and they're still figuring it out. So how is this self-represented individual? I think, I'm just checking here. I thought he was self-represented. Yep, self-represented. So how is this self-represented individual supposed to figure it out when the position keeps changing and the judge says, I'm not sure I get which of the things you've said is the thing that you're saying. When I ask you, do you agree with H in Canada? You say, yes, you do, because H in Canada is a decision that they like. It's one that struck the review application, so they want that to apply. But that one says it's a revocation. And they said, okay, well, yes, we agree with that. And then they say, well, do you agree it's a revocation? Well, no, we want to use this other word instead. I think that this is a big tangled web here, and quite frankly, I think this is a bit of a Gordian knot. The way you cut through all of this is you say it doesn't matter what word you use. Nullification, you can't make up a new word for it. The only question is this a revocation? No matter what you call it, whatever word you use is irrelevant. The way you get to the right answer here is to say, listen, what did it do? Was it a decision made by the registrar? And I think here you have to say, as this court does, yes, because the registrar has to apply the law of the order in council to the specific firearms possessed by, in this case, Mr. Crawford. So you've got a decision. Was the effect of that decision to say that the registration certificates are no longer valid? Yes, it was, because that is the position of the registrar here, is that the certificates are themselves no longer valid. So given that you've got a decision and the effect is to cancel the registration certificates, how can this be anything other than a revocation? So again, I think that the lawyers on this one are doing the best they can with a tough position. I think that they've been handed a position that is very difficult to defend, because that position effectively seems to rely on a language trick to try to shut down a right to otherwise have a decision reviewed. But the thing that's really important to consider when, you might say, well, what does it matter if you get a review? The gun is banned. Well, what if it's not? What if they say that your gun is a variant of a named model and you say, no, it isn't? How do you challenge that decision to decide that your gun is a variant when you say it's not? What happens if they say that your gun is an AR-15 and you're sitting there going, this bolt action hunting rifle is not an AR-15 and has never been an AR-15? How do you challenge that decision? that illustrates that there is a decision made by the registrar, because that decision can be wrong. That decision can be an error. And so the importance of this case and the importance of this challenge to firearm owners in general cannot be understated, because Section 74 is a critical aspect to the functioning of this, and to ensuring that people have due process rights, to ensuring that people are not subject to abuse or to, to irreviewable error. So ultimately, as I said, I think this one's going to have to go to the Supreme Court, but I'm worried about this one. I'm worried about it because I think that the stakes are so high on this particular matter. And yeah, this is, I know I've covered a bunch of cases on the topic of these Section 74 reviews. I'm going to keep covering them because this one has Supreme Court written all over it. The Supreme Court's going to have to sort out these contrary decisions, and it matters to anybody with a firearms license. And frankly, it should matter to people who don't have a firearms license, because if this tactic is accepted here, if it is something where they can just say, well, we've just changed the language, so now you don't get that, court right. You don't get your day in court because we used a different word. If that's accepted, then how is anyone supposed to rely on their procedural protections that are written into the court? How is anyone supposed to have confidence that the courts are available to protect them? One of the key groups that we think of the courts as protecting us from criminals or fraudsters or, somebody who wants to back out of a contract. But one of the key groups that the courts protect us from is the government. And it's very important that we have remedies and that we have means of dealing with it when the government acts in a way that we disagree with or that might be improper. Anyway, I'll cut it off there. I know this one is terribly long, but it's terribly important. Let me know in the comments below what you think. Even if it's just, hey, Runkle, you're a blowhard, shut up. But I think this is an important decision. Let me know if there's something else that's going on in the world you want me to cover. There's a whole bunch of things that are happening, and I'm trying to kind of decide between them. And let me know, just your thoughts. Please also share this video with your friends. Subscribe to see more content. I also want to thank my Patreon supporters who help keep this channel going. It's funding sort of some stuff that's going on behind the scenes, stuff that I hope to be able to bring you fairly soon. Anyway, so at the $50 level, Sir Daniel Wicks of Alberta, Jason Elliott, D. Moe, Canada's National Firearms Association, North Central Process Service, Kyle Martin, and Jean-Guy Toussaint. At the $30 level, Sights and Arms Limited. And at the $20 level, Dale Nesbitt, Cameron Johnson, and Andrew Elsich. Also, a number of you at the $10 level who will be in the crawl immediately following. Thank you once again for watching. This is an important one. It's a lot rides on this, so I hope I've armed you with knowledge.